This Honorable Court of Tennessee is now in session.
Good afternoon. Welcome to the continuation of the March 31st session for the Court of Criminal Appeals in Knoxville. Let me introduce the panel to you. To my left is Judge John Everett Williams from Carroll County. To my right is Judge Robert Holloway from Murray County, and I'm Robert Montgomery from Sullivan County. Each side will have 20 minutes for oral argument. If you're the appellant and wish to reserve time for rebuttal, please let me know as you begin your argument. Madam Clerk, would you call the next case, please?
The State of Tennessee versus Tyrone Murphy.
Okay. Ms. Stivers, are you ready?
Yes, Your Honor. Good afternoon, Your Honors, and may it please the Court. Kendall Stivers with the Appellate Division of the Public Defenders Conference on behalf of Mr. Tyrone Murphy today. Judge Montgomery, I'd like to reserve 3 minutes for rebuttal with Court's approval.
Certainly.
Thank you, Your Honor. Your Honors, Mr. Murphy's appeal today is from a single count of first-degree premeditated murder. Today, we're asking this court to reverse the judgment of the trial court for two reasons. First, the trial court erred in admitting several photographs of the victim's body and finding that their probative value substantially outweighed the danger of unfair prejudice. And the prejudice of admitting these photos, we argue at trial, ultimately denied Mr. Murphy his right to a fair and impartial jury. And second, we argue that there was insufficient evidence for any rational trier of fact to conclude that the victim's death in this case was a premeditated act by Mr. Murphy. The case is, there's a large volume in the record, and ultimately this is a jury trial concerning the killing of a woman in Chattanooga. She lived on the same floor as Mr. Murphy in a home that had been converted into apartments on the second floor. Mr. Murphy testified on his own behalf at trial and admitted that he had stabbed her. So while the trial in this case lasted nearly a week and the factual accounting in my brief is pretty lengthy, there was really only one big issue for the jury to consider, and that was Mr. Murphy's mens rea at the time of the act. As to the photographs, I'll clarify in my brief, the photographs at issue, there were some 56 photographs that were the subject of a motion in limine hearing. We are only challenging 6 of those photographs. They were numbered differently at motion in limine hearing and given different exhibit numbers at trial, but a lot of these are duplicates. The motion in limine numbers of the photos being challenged are 4, 5, 10, 11, 12, and 14, in case my brief wasn't clear about that. And those corresponding trial exhibit numbers are 103, 105, 106, 107, 108, and 109. Once a photograph is deemed relevant by a judge in the motion in limine hearing, the trial court has to conduct a 403 balancing test, as the court is aware, and determine whether the probative value is substantially outweighed by the risk of unfair prejudice. In this case, before the photograph can be admitted. And the prejudice becomes unfair when the photograph's primary purpose is to elicit bias, sympathy, contempt, horror. Those are just some of the language that the case law uses. But ultimately, it's whether or not these are actually for use in proving something at trial or if they're just to inflame the passions of the jury. And we've also provided in our brief the factors from the Banks case, which deals explicitly with the balancing test in consideration for photos of homicide victims. And those include 4 of them. Their accuracy and clarity, they were very clear in this case. Whether or not they were taken before the body was moved, the adequacy of the trial testimony in conveying what the photographs are intended to show, and then the need for these photos to establish a prima facie case for guilt. The trial court found in the motion in limine hearing that the probative value outweighed the risks in each of these photographs for unfair prejudice. But we argue in our brief that these photos serve no evidentiary purpose at trial other than to elicit sympathy and horror from the jury. For example, trial exhibit 103 showed a hand covered in blood, full color, that no DNA swabs were collected from. Same for 105, which shows her arm. They're also adequately shown in other trial exhibits that show a full body picture of how she was found when the police entered her apartment. And the remaining 4 that we challenge, although they show DNA swab areas, only one of them had Mr. Murphy's DNA on them. And again, they were adequately represented by full body pictures from both the location of the body at the scene, at the crime scene, and at the autopsy. And as a result, we'd argue that the bank's factors fall in our favor in this regard. We're also aware that even though this may be an error for the trial court to admit it, it has to show that there was some sort of overarching effect that this had on what the jury decided. And we would argue that given the nature of this case, it contributed to what we would argue would be an error on, or what we would argue would be insufficient evidence for the jury to find premeditation. In regards to our second argument in our brief, as the court is familiar, first-degree premeditated murder requires proof beyond a reasonable doubt of both intentional action on the part of the defendant. It was a conscious objective or desire to cause the death of the victim, as well as premeditation. We're aware that premeditation, there's no specific time limit. It just must be one that is done after the exercise of reflection and judgment and formed prior to the act itself. Both the counsel for the state and I referenced numerous factors that have been found to be consistent with or indicative of premeditation, and several of them are present in this case. There were numerous stab wounds in this case. Both the number and the fact that these were stab wounds would tend to indicate or fall in the state's favor that this might be a premeditated act. And there was a concealment of some of the evidence in the basement of the house, but this concealment happened after the fact. And we argue that the presence or the cumulative effect of these factors would not lead a rational trier of fact to conclude the distinguishing element of first-degree murder, premeditated murder, we argue, from all other forms of killing. What we learned in our criminal law classes is malice aforethought or lying in wait, or ultimately these factors are intended to gauge the fact that this didn't just spring up or happened in the heat of the moment, that this was something that was carefully planned and intended, an act by a predator on their prey.
Ms. Tyrone,
yes,
just
Judge.
ask one question. You're not claiming this was a crime of passion or anything like that, or you're sort of saying it's second degree murder, not first degree? I'm not trying to put words in your mouth.
No, we argue that there was argument put forth at trial that this may have been voluntary manslaughter, and Mr. Murphy's testimony did indicate self-defense, but as the court is well aware, the jury was free to believe that or not, and he was the only person essentially that put forth evidence of the self-defense. So while we did argue that, I think it could go either way in that regard, and it tends to be, as I mentioned in my reply brief, and I don't think the state has had the chance to address that yet. This is more in line with a knowing killing, or something that was done without being premeditated or planned. The facts indicated that they didn't really know each other beforehand. Another witness testified maybe that they had hung out for a brief bit, but there was simply nothing from Mr. Murphy, whose testimony may have ultimately been discredited by the jury. Nothing that indicated a reason for bad blood prior to that night between the two persons, which would leave us with the argument, which is our argument in this brief, that the jury was left with nothing really indicating that Mr. Murphy had any ounce of premeditation, and that this was more in line with a knowing killing that kind of sprung up in the heat of the moment. If the court has no other questions, I'll reserve my time for rebuttal from the state.
Let me ask one more question. This may be more appropriate to ask to the state, but are there any cases that you have found where there are multiple stabbings or it can be multiple shootings, where the court has used the number as showing premeditation? Does that make sense?
I think so. Kind of like when we do sentencing, a certain number of crimes may indicate or tip the scale between an extensive criminal history,
Right. You know,
something like that.
he may have not known what he was doing the first time, but by the 15th time or whatever time, you know, he was premeditated in doing that stabbing, and we don't know which one killed him.
I don't think there's one that shows a certain number. I think the ones that have indicated, there was one that I included in my brief that was a fight that erupted between two men at a bar. Alcohol was involved, and there was a knife, where the case law has distinguished between a knife being more personal versus multiple gunshot wounds where you don't have that intimacy. But that case, there were numerous stab wounds. I don't know if there was an exact number, but I think it's kind of that tipping of the scale between. There's not an exact number, but once you get above a certain number, it's kind of like, you know, that was enough. I think repeated blows can be delivered in the heat of passion with no design to reflect. So again, it's not trying to weasel out of it, but it is one of those ones that's a case by case basis.
Okay.
Thank you, Judge. I'll rest on that and reserve the rest of my time for rebuttal, if the court please.
All right, General.
Thank you, and good afternoon, Your Honors. May it please the court. Alex Carver on behalf of the state of Tennessee. This court should affirm the defendant's conviction for first-degree murder because the trial court did not abuse its discretion in admitting photographs of the victim's body, and because the evidence of premeditation was sufficient to support the jury's verdict. I'll begin with the photographs issue, as my opposing friend on the other side did. And I'll just note that I appreciate the limiting the discussion to the 6 photographs that are challenged here. I think I discussed 8 in our brief, but the defendant has made clear that exhibits 7 and 8 at the motion and lemonade trial, which I discussed in the brief, are not at issue in this appeal. Under Rule 403 and the Tennessee Supreme Court's decision in Banks, post-mortem photographs are admissible unless their probative value is substantially outweighed by the danger of unfair prejudice. That rule reflects a liberal policy that favors the admission of photographic evidence, and defendants bear a heavy burden to exclude this kind of evidence. That is especially true in prosecutions for first-degree murder, where the state bears the burden of proving premeditation beyond a reasonable doubt. Because the victim's wounds are often some of the only probative evidence of a defendant's mental state at the time of a killing, even graphic and disturbing photographs will often be admissible in murder prosecutions. I think that principle is clearly illustrated in the Supreme Court's recent decisions in Davidson and Willis, which upheld the admission of photographs far more graphic than those at issue in this case. Here, the probative value of the challenged photographs is not substantially outweighed by the danger of unfair prejudice. The challenged photographs all have significant probative value for several reasons. And I'll first point out that I think the defendant in his brief takes an overly narrow view of the probative value for which these photographs were offered below. The transcript of the motion and lemonade hearing, which is volume 2 of the record, makes clear that these photographs were not offered merely to show the location of blood samples taken for DNA analysis. They were offered for that, but they were offered for many other reasons also, as both the prosecution and the trial judge made clear at that hearing. Some of those other reasons that show the probative value of these photographs would be that exhibits 4, 5, and 7 show defensive wounds on the victim's hands and arms, which were highly relevant to rebut the defendant's claim of self-defense. Several of the exhibits showed the vicious nature of the attack, the particular cruelty of the killing, which is a factor that goes towards premeditation. Exhibits 5 and 12 were probative of the defendant's motive because they showed the state of the victim's clothing and the blood that the defendant smeared on her legs and inner thighs, perhaps as he was trying to pry her legs apart, which, as I'll explain shortly, could permit a rational jury to find that the killing was sexually motivated, which also goes towards premeditation. And finally, Exhibit 14 was probative because it showed the location on Ms. Cates's abdomen where the defendant's own blood was found, directly linking him to the crime. In addition to the significant probative value of each of these photographs, the photographs here were not unfairly prejudicial. And I think it's important to keep in mind that the Tennessee Supreme Court has made clear that what matters in this inquiry is not whether the photographs were prejudicial, but whether they were unfairly prejudicial, as the court made clear in Davidson and in Willis. And here, any prejudice created by the unpleasant nature of the photographs is not unfair to the defendant, because the crime the defendant committed was a gruesome one. And I'd also point out that these photographs are not outside the norm in murder prosecutions where the victim died of knife wounds. They are far less graphic than other photographs the Supreme Court has allowed, including some in Willis that made a juror become physically ill at viewing them. They're also far less disturbing than photographs that this court has ruled inadmissible, such as in the Harper case, which involved truly horrifying images in a vehicular homicide involving a pregnant woman, in which two of the members of this panel served on that panel as well. I think these photographs are a far cry from anything like that. Unpleasant. The defendant suggests in his brief that perhaps the crime scene photographs should have been admitted in black and white, but there is no requirement that all photographs in murder prosecutions always be admitted in black and white. And the Supreme Court has consistently upheld the admission of color crime scene photographs. So given that precedent, I don't think we can say that the trial court clearly abused its discretion in deciding to admit these photographs in color. Finally, the photographs are not needlessly cumulative. Each one of them reveals something different about either Ms. Cates's wounds or the scene of the crime that the others do not. And although there is some overlap among the crime scene photographs and also between the photographs from the crime scene and the autopsy photographs, the Supreme Court has again upheld the admission of overlapping photographic and video evidence, including the admission of both crime scene and autopsy photographs before. I would refer the court to the Reed case, the Bigby decision, and the Smith decision, all cited in our brief. And finally, I would just note that the prosecution was very selective in the photographs it chose to admit in this case. Exhibit 57 at the motion in limine hearing shows 21 crime scene photographs that the state chose not to offer into evidence, many of which were much more graphic than those that it did admit. The trial court found as much on pages 19 and 23 of the hearing transcript. And lastly, on this issue, I would submit that even if the trial court abused its discretion in admitting the photographs, the error was harmless given the overwhelming evidence against the defendant, which I'll discuss shortly. Unless the court has any further questions about the photographs, I will turn to the sufficiency of the evidence. I think I'll start by discussing Judge Holloway's question to my friend on the other side about about the role of the number of wounds a victim sustains in determining whether there was sufficient evidence of premeditation. And I believe you asked whether there were any cases where the court has relied on the number to find premeditation. And a couple of the cases cited in the defendant's brief, so State versus Nichols, cited by the defendant, it involved a case where you actually had evidence that the defendant and victim were arguing. The defendant grabbed a kitchen knife and stabbed the victim 3 times, each time inflicting a life-threatening injury, and then cleaned the knife. And the Supreme Court held that, while not overwhelming, that evidence was sufficient to support findings of both premeditation and deliberation. Similarly, in State versus Bland, which is also cited in and I believe both briefs, but in the defendant's brief, definitely, that was a shooting case where the defendant pulled the trigger on 3 separate occasions, and the court held that the jury logically could have concluded that the defendant had time to reflect and choose a course of action where the defendant was shot 3 separate times. So if that's the case, 3 times pulling the trigger, I think 20 times stabbing the knife, it applies with even greater force to this case. And I'd also refer the court to the Adams decision, the 2013 decision from the Tennessee Supreme Court that also involved many stab wounds and supports a finding of premeditation. In addition to the sheer number of wounds that Ms. Cates sustained, I think several other pieces of evidence strongly support a finding of premeditation. I would point to the location of her wounds. She was stabbed 15 times in the head, neck, and chest, which are vital areas of the body, and which suggests that the defendant was trying to kill her, purposefully aiming for her vital areas, and that he would have had time during the many wounds that he inflicted to those areas to undertake the necessary reflection and judgment for premeditation. And the severity of the wounds that she suffered also support premeditation. 4 of her wounds would have been individually fatal on their own to kill her. And on one occasion, the defendant stabbed her with enough force to nearly sever her trachea, and another time with enough force to break the tip of the knife off in her skull. All of these facts about the wounds made clear that the jury could have found that premeditation was the best explanation. At bottom, the jury was faced with really 2 different explanations to account for these wounds at trial. The state offered a theory of first-degree premeditated murder, and the defendant took the stand and testified in his own defense that he inflicted these wounds in self-defense. On appeal, the defendant asks this court to find the jury was compelled to find that he acted in the heat of passion and therefore should have only been convicted of voluntary manslaughter. But the big problem with that argument is that the defendant's testimony at trial never suggested that he was provoked to attack Miss Cates after she allegedly cut his hand, and that he then killed her in a state of passion. He instead maintained consistently that he held her wrists and begged her to drop the knives, and that she tragically lost her life when he was unable to stop the assault. And if the jury rejected that implausible self-defense theory, the only other theory that adequately explained the evidence was premeditation. The defendant's actions after the murder also support the jury's finding of premeditation. The defendant admitted at trial that he made no attempt to render aid or assistance to Miss Cates. He instead cleaned up the crime scene, tried to make it look like a robbery, and hid evidence. And my friend on the other side noted that the evidence was hidden after the commission of the crime, but that type of evidence can still support premeditation. I would refer the court to the Leach case from the Tennessee Supreme Court, which is cited in our brief, where the court relied on the fact that the defendant had flushed underwear down the toilet after the crime in support of, in finding that the evidence was sufficient to prove premeditation. The defendant also exhibited calmness after the killing by having a conversation with his neighbor, DJ Weaver, only hours after the killing, in which the neighbor, Ms. Weaver, testified that he was his usual happy-go-lucky self. And that calm demeanor, again, supports the jury's finding in this case. And then lastly, I would note that establishing a motive for the killing is also a factor from which the jury may infer premeditation. And here, the state of Ms. Cates' clothing, the blood smears on her inner thighs, all of that could have permitted a rational jury to conclude that the killing was sexually motivated. Now, the defendant points out in his brief that there might have been other explanations for this evidence other than a sexual motive. And that might be true, but it was up for the jury to decide what to make of this evidence. And this court must draw all reasonable inferences in favor of the prosecution on appeal. And this is certainly a reasonable inference the jury was entitled to make. I would also note that I believe, Judge Holloway, you asked about whether the defendant was urging that this conviction be modified to second-degree murder or voluntary manslaughter. And in the defendant's opening brief, the defendant asks only that this court modify his conviction to voluntary manslaughter. And we certainly think the evidence was sufficient to prove first-degree premeditated murder. And our alternative position, if the court were to disagree, is that it should modify the defendant's conviction to second-degree murder, not voluntary manslaughter, because the evidence was at the very least sufficient to establish a knowing killing. But we certainly believe that the evidence was more than sufficient to support the jury's verdict of first-degree murder, and would ask the court to affirm that conviction. Unless there are any further questions, the state respectfully requests that this court affirm.
Ms. Stivers, rebuttal.
Thank you, Judge Montgomery. I'll just address a few points just to clarify some of counsel for the state's arguments. In terms of the evidence, and I know counsel for state mentioned the Harper case, in which I believe there was a reversal in that case. That was the car accident. There's still, no matter what, has to be a causal connection between the piece of evidence, not just that it's relevant because they were, in this case, pictures of the deceased and maybe some of her wounds, but a causal connection that aids the jurors in coming to a resolution on the elements of the offense. And if it does not do that, then it should not be admitted. Regardless of how many photographs the state did not bring in at the motion in limine, that doesn't earn them credits toward being able to get some other ones in. They still have to prove that causal connection and the fact that they are not going to unduly prejudice or they're not going to unfairly prejudice the defendant at trial. And second, in terms of the Leach case where the evidence was flushed down the toilet, Mr. Murphy did not select the best hiding place for his the concealment of several items after the crime, which we would indicate should rationally give an inference. It took police maybe a day to find it. Should give an inference rather than somebody doing something like flushing underwear down the toilet in a manner that is going to, unless it clogs the system, going to render it irretrievable. This was found quite easily. And second, although the defense may be implausible as the state characterized it, would advise of Sherlock Holmes's words that implausible and impossible are two different things, and it is not outside the realm of possibility that, or indeed for a rational jury to find that this was just something that was done after an argument sprung up. Mr. Murphy testified that that he did attempt to stop an attack, that she attacked him. Of course, as counsel points out, the jury was free to disregard that, but it just doesn't seem to be any reasonable inference to draw from that for the jury that this was something that was premeditated. And with that, if your honors don't have any more questions, I'll conclude.
Okay. All right. Thank you. And thank you to the attorneys for participating in oral argument using this format today. Our court greatly appreciates your working with us to have your cases heard virtually. I also want to thank the staff with the Administrative Office of the Courts, as well as the Appellate Court Clerk staff, in providing invaluable assistance to us in this hearing today. And with that, we will be adjourned until our April session in Knoxville. Madam Clerk?
This Honorable Court of Tennessee stands adjourned.